Oh gosh, welcome, welcome, welcome. You know, I'm so glad you're joining us for Moore Up North. We're tackling a sort of, well, a very thick and serious subject, and this is going to be the first in a series of several because there's so much information and so much research to be done on the relationships between tribes, corporations, Alaska, the feds, and you know, I figured I'm a green-eyed blonde from Homer. Who else is going to do this? So I picked me. So anyway, please join us for Moore Up North. Yeah. Welcome back. Thank you. Welcome back. Welcome back to Moore Up North. I'm Shannyn Moore, and I'm very pleased that tonight we're going into a topic that, you know, it's all around us, and I don't think very many people have very accurate information, if any information at all, when it comes to Alaska Native sovereignty issues, when it comes to what's a corporation, what's a tribe. These things affect us in huge ways, whether you're Alaska Native or not. There's always the questions of subsistence, the questions of adoption, the questions of, you know, whose land is whose land, and what exactly are these corporations again? So I'm very happy that Heather Kendall-Miller has come in. She's a senior attorney with the Native American Rights Fund, and she's been on the front line of tribal rights battles over adoption, over subsistence, taxation, and many, many other issues. So welcome to the show.
Thank you, Shannon. It's a pleasure to be here.
Well, I know that a lot of people know that we have Native corporations in Alaska. I know that most people know that we don't have reservations. We sort of have these financial reservations of sorts. Can you talk about how that happened versus what happened, say, in Oklahoma or New Mexico or Colorado or other places?
Well, a lot of the history is due to the fact that Alaska joined the Union late, and many of the we joined the Union after Congress stopped entering into treaties with tribes. Nonetheless, Congress early on recognized that indigenous peoples were in Alaska and established a relationship with those peoples of care and treated them as tribes elsewhere. And we have a very long history establishing that the Bureau of Indian Affairs provided services, health, school for natives. The question, however, is whether or not these native villages were actually tribes possessed of inherent sovereignty was a little bit unclear for a matter of years. And that was due in part because, as you say, the creation of corporations and such, that was the result of what was the Alaska Native Claims Settlement Act, wherein Congress decided that they would try something different with Alaska Natives. The Native leadership at the time did not want to be under the supervision of the federal government, and that's how it is in the lower 48 with respect to reservations. Anytime a tribe wants to engage in economic activity, they have to get permission first from the Secretary of the Interior. Native leadership in Alaska did not want to be under such direct supervision, and they wanted to have or be given the tools to make more decisions for themselves. So Congress decided that it would try something different, and instead of extinguishing Aboriginal title and reserving to Indians a reservation over which to live, they extinguished Aboriginal title and conveyed the land in fee to these newly created corporations with the idea that they would be able to engage in the economic machine and thereby bring Alaska Natives into the economic mainstream, thinking that that would be a viable tool in which to empower and enable them. The problem is that the Land Claims Settlement Act, although it created these corporations, never did address the question of tribes and whether or not tribes continue to exist with inherent powers of sovereignty over their members and non-natives. If you if a non-member drives onto a reservation in the lower 48, they fall within the jurisdiction of a tribe for certain purposes. Here, because the lands were conveyed to corporations in fee, the question remained whether or not those lands continued to hold the status like reservations. And that question was eventually brought before the United States Supreme Court well over a decade ago, and the question there was whether or not Angska lands qualify as Indian country, which includes reservations, native allotments, and other forms of Indian lands. And if so, then whether tribes can exercise jurisdiction tax in that sense. And the Supreme Court held no in the case of Angska lands, that they are fee lands, and because they're fee lands, the federal government doesn't have the level of control and supervision over them. That's all that case concerned. The question then remained the extent to which tribes exist and are able to regulate activities of members. And that question was taken up by the Alaska Supreme Court shortly after the Indian Country case, and that court, the Alaska Supreme Court, conclusively held, yes, they do. And that was based upon a series of federal actions that were taken over the course of many years by the executive office, by Congress, and by the courts, holding that Alaska tribes are essentially the same as tribes elsewhere. They are governments possessing inherent sovereignty over their own members. And that's the basis by which tribes continue to this day in Alaska to be able to adjudicate things like custody, like adoptions, any kind of domestic relations among their members.
So when you're looking at now, I mean, we've got corporations. Do those corporations then become their own government?
No.
Or is there a separate entity for this? Because that's what, I mean, we're talking about that there are these corporations here that represent the First People of Alaska. And then there's the issues of sovereignty, but it's not the corporations that are sovereign governments.
That's right. That's right. And there's a very clear line. The corporations are exactly that. They are businesses. And their first obligation is to their shareholders. They are not governments. They are businesses that conduct their operations based upon a combination of federal and state law. Only those natives that were born as of 1971 became shareholders. But all the children of natives, like myself, my daughters, and my grandchildren, they're also tribal members. They may or may not be shareholders in a corporation, but they are tribal members of a particular village tribe. So the corporations have a sphere, and that is to engage in this economic activity and make money and provide checks to their shareholders, but they are not governments. They do not possess governing authority to regulate or to govern members. That solely rests in the tribal governments.
So who do you think is more powerful when it comes to negotiations then right now? Is it the tribes or is it the corporations?
It depends upon what's being negotiated. You know, the corporations did succeed in getting an executive order that treats them like governments for purposes of consultation. Now, the federal government, by virtue of having a government-to-government relationship with tribes, has an obligation to consult with tribes whenever it undertakes an activity that may affect a tribe. So therefore, in the state of Alaska, each of the federal agencies have an obligation to consult with tribes on a government-to-government basis. They likewise do have that obligation with corporations, but the kind of consultation that they engage in is very different.
Well, I know we don't have very much time left, but I understand that the most kickback that the sovereignty of tribes in Alaska is getting is from the state of Alaska right now. Can you answer that question in just a couple of minutes?
I'll try to. It's ridiculous in the sense that the state of Alaska, at one time during the Knowles years, decided enough is enough. We're not going to continue to battle against tribes. We accept and recognize that the federal government acknowledges tribes in Alaska. Therefore, we will. And the Knowles administration adopted a Millennium Agreement in which he directed all of his agencies to likewise treat with tribes as sovereigns. We got a new governor with Governor Murkowski. He brings in an attorney general that says, wait a minute, that's not what we're going to do. And they reinvent the wheel. And they try to dig up new arguments why the state should not recognize tribal governments. And unfortunately, Sarah Palin and now Governor Parnell has adhered to those policies. And we have found ourselves litigating in both federal and state court some of the same issues that we litigated earlier and won.